Good morning, Mr. Garcia and Mr. Tinker. We are ready to proceed, Mr. Garcia, as soon as you're set.
Good morning. May it please the court, David Garcia on behalf of plaintiffs Christopher and Rosaline Marillion. Your Honors, we're here today seeking review of a final judgment that was entered in conformity with an arbitration ruling. We believe that the issues of law that are being reviewed are to be reviewed under a de novo standard. And just by way of a very brief background, and I think it is extremely important, that's why I'll waste a few minutes on it, but this is a Hurricane Irma insurance claim that was filed by the homeowners to their insurance company, People's Trust. The claim was undisputedly reported approximately a week after the storm. The insurance carrier proceeded to investigate the claim by inspecting the property, and shortly thereafter, the insurance company, sometime in November of 2017, acknowledged coverage for this loss. Now, People's Trust did not make a payment for the loss. Instead, they opted to repair. It's undisputed this policy carries an option to repair, and that option was invoked by the insurance company on November 24th, 2017. Now, in response to that, my client proceeded by providing some information that had been requested by the insurance company, and I'll move on later to discuss why this was gratuitous in terms of my client having provided these documents. But to sum it up, my client did provide a sworn proof of loss, which had the information to the best knowledge and belief that my client had at the time, my client being just a layperson, not an adjuster, not a contractor, nice folks who own a home. So the claim proceeds, they invoke their option. My client sends a sworn proof of loss. My client also submits a written work authorization, and later, sometime in about February of 2018, after certain correspondences back and forth, my client, again, through my law firm, its adjuster, indicated to the insurance company that we were not disputing their right to repair. In fact, we were inviting them to repair the property in accordance with the option that had been invoked. The case law in Florida, as cited in the complaint as well as in the brief, is pretty clear that when it comes to an option to repair, an insurance company may invoke its option, and once it does so, its responsibility and duty is clear. The insurance company must—
Mr. Garcia?
Yes, Your Honor.
Apart from the sworn proof of claim, what information, or in the proof of claim, what information did your client provide as to what was in dispute in terms of what the insurance company had indicated would be repaired based on their information versus what your clients how they disagreed with that?
Thank you, Your Honor. Before this lawsuit was filed, there was never any dispute or disagreement with the scope that was provided by the insurance company. My client, and again, I emphasized it earlier, but the requirement in the policy, and that's what governs our relationship here, the policy states that the sworn proof of loss must be provided to the best of the insured's knowledge and belief. There is no finding in this case that my client withheld any information that he had available to him at any point pre.
So is it your position that an insured can simply say, we disagree with your evaluation, this is our proof of loss and our sworn statement, we simply disagree with what you have evaluated? Is that sufficient?
I don't know if that would be sufficient, Your Honor, but I don't think that's what happened here. My client, again, never disputed or disagreed with the insurance company. And I'll just get right back to the Drew contract that was created in this case. Under Drew, the insurance company, upon invoking its option, had the obligation to restore the property to substantially the same condition within a reasonable time. That is what was required. That's the new contractual relationship that existed between People's Trust and the Marillions as of November 24th, 2017. And ever since that date, my client did nothing to frustrate that new relationship. My
So
client,
after the arbitrator ruled against your client, what was done to let the trial court know that you were still disagreeing with what the evaluation had been and with what the arbitrator had determined?
well, in this case, no trial de novo was requested. And I mentioned it earlier that we are not seeking, I guess, review of the factual determinations or findings of fact made by the arbitrator. The findings of fact are exactly as I recited. There's a covered hurricane claim. My client provided a sworn proof and a work authorization.
So what was the legal error that the trial court committed when it entered a judgment based upon the arbitration finding and an award when there was no request for a trial de novo?
Thank you, Your Honor. Facially, right on the face of the final judgment. And I'll point out that this is a unique case because my client did not sue their insurance company. That's the progeny of cases that is cited all over the complaint as well as the brief. This case is unique in that context because People's Trust sued my client for breach of contract, and at the award that was entered by the arbitrator was in favor of People's Trust. You are correct. Now, the reason that that is facially deficient and facially incorrect as a matter of law is because a quintessential element of a breach of contract, Your Honor, and I think this goes back to law school, is damages. There must be damages for there to be a breach of contract. Now, what's interesting is that in the entire complaint, there is no allegation of damages. And in fact, paragraph 52,
help me out, because I'm going to be honest, counsel, you just lost me on your analysis, on what your analytical point is. My original question, circling back to, is what was the legal error that this trial court committed when it entered a judgment based upon an arbitration award that had not, where under section 44.103, where there had been no request for a trial de novo, which under 103 sub 5 contains a mandatory, you shall request a trial de novo if you wish to challenge the arbitration award. What was the legal error here?
Well, Your Honor, I don't believe Judge Brody made the legal error here. She entered the judgment in conformity with the findings, and I don't think that I've seen any cases cited by the defendant that indicate that you must request a trial de novo rather than seek review of facially inaccurate.
The statute says you shall. Help me out with that language. What do you do with that?
And
it says if you want a trial, if you don't like the arbitration award, if you want a trial de novo, you shall request a trial de novo. You didn't do that. How do we review the arbitration award at this point in line with what 44.103 sub 5 tells us is supposed to happen below?
Well, the rule of civil procedure, I think, may be distinguishable in that it says any party may file a motion for a new trial. And in this case, we elected not to file a motion for new trial, rather accepting the findings of law, or I'm sorry, accepting the findings of fact and challenging the validity of the legal conclusions. And again, just on its face, there were never any damages asserted in this claim. And if interestingly, in the award, in the final judgment that we're taking issue with here, in the final judgment where the court or the arbitrator has found that there was a breach of contract on behalf of the policyholder and in favor, let's say, of the insurer, in this final judgment, there are no damages that were awarded. And of course, that's because there were no damages that were alleged. And even more importantly, that's because there were no damages.
Mr. Garcia.
I'm sorry, I just don't understand what that has to do with your argument.
If a breach of contract was found to exist and there are no damages which support or are found in that judgment, or that
it was a deck action though, right? Wasn't what the insurance company sought was just basically a declaration here? That
was one of the causes of action, but there's not a single mention of the deck action in the appraisal award or the final judgment. It's a breach of contract that's the legal determination that was made, was that the policyholder, the homeowner, breached this contract. And for that to happen, there would have had to have been damages to the insurance company. There were none. There were none alleged. There were never any asserted. And I think that in of itself, Judge, is a legally deficient finding of law by the lower court or by the.
Mr. Garcia, what legal precedent gives you the right of appellate review of this decision when you didn't preserve any errors of the arbitrator's decision before the trial judge and had them adjudicated then? You had a right to file exceptions. You had a right to file trial de novo. You had a right to point out any errors and bring them before the trial judge. I think what Judge Lucas is saying is the judge below did basically a ministerial act, which he or she was required to do. Now you're telling us, just based on the face of this, there is an error that was never brought before the trial court, ever. What entitles you to review up here?
Your Honor, this is a final judgment. Like any other final judgment, I believe if it is faulty or inaccurate as to the findings of law, there exists appellate review for those issues of or questions of law. And I understand in the statute that if no if no trial de novo is requested, it becomes final. And of course, it's ministerial. The lower court enters final judgment in conformity with the award. But I don't believe the statute or the rule or any case that I have seen eliminates the possibility of challenging the final judgment, just as any other final judgment may be challenged. In this case, I can tell you as a matter of practice, the reasoning is that no matter, and there's a long-standing relationship, I would call it, between my law firm and this defendant, the insurance company, and many appeals have been taken on these issues. More than 10 appeals have been taken.
That doesn't matter. We don't care about that. We care about this one because the rules are fair and they provide you with a remedy. If you disagree with this arbitrator decided and he or she didn't apply the law correctly, you have a remedy. It's called a trial de novo. You didn't take advantage of that. So that goes before this judge. So right now, we're really not, there is no legal error right now by the trial judge. You're saying that the arbitrator made a legal error, but you didn't ever attack that. Why not?
Because whether or not we attacked it, Judge, and let's say we successfully attacked it, we asked.
No, don't give me a hypothetical because you didn't.
Fair enough, Judge, but let's just go down that road. If we would have attacked it and it would have been a trial de novo, and let's say we are successful in this trial, in the trial anew, and ultimately what we've learned from practice, Judge, is that this issue, no matter who wins, us or them, it ends up in an appeal, Judge. My client's home needs to be repaired. It's been 3 years literally since the storm.
Mr. Garcia, if it ends up in an appeal after a trial de novo, then we have legal rulings by the trial court that are subject to review. Without a trial de novo, we have a ministerial act by the trial court that you're asking us to review. And I don't see any authority that suggests your position is correct.
Fair enough, Your Honor. What I will point out is that all of the authority cited by the defendant, if there was a case out there that said that we could not seek this appeal, I feel that there should have been a case cited by the defendant or by the appellee stating that you can't seek appellate review of a final judgment entered in conformity with an arbitration award. You must seek a trial de novo first.
I think what you're probably bumping up against, counsel, is not necessarily a question of whether or not we can review it, but what is it we can review at this point, since you never requested a trial de novo. I think what I'm hearing you saying is that you just wanted to fast forward, get to the DCA and have a determination made about coverage without going through and hey, we went through an arbitration. Why do we got to go through do this all over again? Look, you may not be big fans of Section 44.103 as an alternative dispute resolution mechanism. I know when I was in private practice, I wasn't a fan of it, but it's there, and the trial court has the authority to refer you all to it, and it did, and there's a mechanism by which you can challenge that. I'm just not sure how you get past that obstacle.
And Mr.
Fair enough, Your Honor.
Garcia, let me just say for a moment, I think we have a good handle on your argument. You have 4 minutes left. If you want to reserve any time for rebuttal, you didn't ask for it early on, but I wanted to let you know where you are in your timing.
I appreciate that, Judge, and I did realize I kind of overlooked that. I will reserve the rest of my time for rebuttal. I appreciate the heads up.
Very good. You'll have 4 minutes. Mr. Tinker?
Morning, may it please the court. Mark Tinker on behalf of People's Trust Insurance Company. I think the court has a good handle on our arguments, and the position or an argument that was just made by Mr. Garcia was if there was a case out there on point, we would have cited it, and we did cite it. And I'm not a big fan of reading quotes to the court during oral argument, but I think this sums it up. It is the Florida Supreme Court in Schneermacher Holding versus Noriega. The quote is, "The award of arbitrators in statutory arbitration proceedings cannot be set aside for mere errors of judgment, either as to the law or as to the facts, and neither a trial court nor a district court of appeal has the authority to overturn the award." And that's essentially my argument, Your Honors. There was no trial de novo requested. The judge had no authority to do anything other than enter the judgment, and this court has no authority to overturn it. Unless you have any questions, I thank you for your time.
Very good. Thank you, Mr. Tinker. Mr. Garcia?
Thank you, Judge. And I'll address that case specifically. The Schneermacher case, I think, provides a level of guidance to myself and my client as to how to proceed in this instance. And what I gather from the Schneermacher case is the one thing that we should not have done was filed a motion to vacate the award. That's what that case stands for. A motion to vacate the award must be under one of the 5 statutory guidelines. And we're not any of those, Judge. We're not asserting that we are. There's no fraud, mistake, inadvertence, that kind of thing. So, the Schneermacher case, I think, is very centrally focused on the fact that it was the appeal of a motion to vacate. And the court said that was not the correct vehicle. And here, what counsel just read, I believe, is specifically centrally focusing on a motion to vacate. And if a motion, you can't attack on a motion to vacate, you can't attack legal conclusions because that's not one of the 5 statutory guidelines or principles. So Schneermacher, I don't think, provides guidance to this court in terms of stating what counsel or the appellee is stating. And that is to say, they're trying to convert Schneermacher into, you must file a trial de novo before seeking appellate review of a facially invalid final judgment. And that's not what it says, Your Honor. And I can go through each of the cases cited by the defendant, or I'm sorry, by the appellee. I keep confusing it. So in this case, Judge, I believe that we certainly did have the right, respectfully, to seek review of a facially invalid final judgment. I already touched on the fact that the damages is a very big problem for the finding, or the legal finding that there was a breach. It cannot happen if there were no damages found or awarded. It's illogical, and it's not a breach of contract as a matter of law. Our brief touches on the sworn proof issue and how it wasn't even necessary, and that's what gave rise to the breach in the eyes of the lower court. And I think the brief sufficiently lays out that argument. But I do believe, or it's our position respectfully to the court, that we can challenge the facial validity of the legal conclusions in this final judgment as we could in any other. Thank you, Your Honors.
Very good. Thank you, Mr. Garcia and Mr. Tinker. You'll be asked to exit the virtual courtroom. And the next case that we will hear is Paulton and Stowers versus H&H Ferguson's Contracting.